take a look at evidence. Using the evidence rules. First, some common evidence traps. We too frequently hear from people who say, well, I had an affidavit and the court wouldn't let me use it. That's because an affidavit is generally hearsay. It's an out-of-court statement offered to prove the truth of what it contains. So it's hearsay, and we'll explain that in a moment. Be very careful when you're trying to use affidavits. They are generally not admissible by themselves to prove the truth of what they say. They're hearsay. Failed authentication is also a trap. People that come to court, they have a copy of a telephone bill, or they have a letter from Aunt Susie, but Aunt Susie is not there, and there's no representative from the telephone company to authenticate the telephone bill, and so the paper is hearsay. It can't come in. These are evidence traps. We'll get into more detail about evidence here in just a moment, but we need you to remember that just because you think it's evidence doesn't mean it is evidence. You need to understand evidence rules because your whole case depends on it. When to object and when not to. Well, anytime anything's coming in that you don't want to come in, if you can get away with it, object. If there's any reason whatsoever to object to it, object. But sometimes the other side may be offering the testimony of a witness, and it might be hearsay, but it might help you. So if it's helping you, let the other side get away with it. You object when it's not favorable to you, and you have a legal basis to object. And when it is favorable to you, even though it may be an improper statement, or it may be hearsay, it may be inadmissible evidence when it's coming in, but if the other fellow is offering it, and it's going to help you, there's no reason to object. So just because something's hearsay or inadmissible doesn't necessarily mean that we want to object to it. Motions for judicial notice generally fall under evidence rules. This is where you have a right to move the court to enter an order taking judicial notice that a particular statute or opinion of a court or a treaty is effective and that it controls the court where your case is pending. You need to learn more about this, and this is explained again in more detail in our tutorial collection. Simplifying the evidence rules. It comes down to basically is whether or not a fact that's offered into evidence is admissible. Generally, this is based on whether or not, first of all, is it relevant? In other words, does this particular fact or this piece of evidence have any reasonable probability of affecting the outcome of the case? If it isn't going to affect the outcome of the case, and another way of saying that is if it doesn't relate directly to one or more elements of the causes of action, then it's not relevant. Another question we have is whether it's reliable. Children talk to their toys. We don't allow children to testify in court because their testimony is not reliable. Credibility and competence are two other factors we use to determine admissibility and the value of evidence. Credibility depends not only on the character of the witness, if it's a witness that's testifying, but it's also whether or not the witness is actually talking about something that he knows about. This is what we talk about when we say that a witness is competent to testify if he has first-hand knowledge. If the only thing that he knows about the case is what he heard from someone else, then his testimony is not admitted. It's not admissible. Privilege and prejudice are two other things. Privilege is such as the right that you have to prevent your attorney from telling somebody else what you confided with him in private, or what you talked with your wife about, or you talked to your priest about. Communications that were made in private, intended to be confidential, are inadmissible. Prejudice is another factor that we look at. For example, if you have a case involving some gruesome crime where there's some very inflammatory evidence, some photographs of some very unpleasant scenes. These things can be kept out of the court because they would prejudice the jury, prejudice the court, and so that's another basis for admissibility. We'll look into some of these things again in more detail, and of course in the tutorial collection you'll find a great deal more detail about these things. Hearsay, what it is really. Hearsay is very simply an out-of-court statement offered to prove the truth of what it says. That's why an affidavit is hearsay, because it's made out of court and it's offered to prove the truth of what it says. That's all that hearsay is. So anything that constitutes an out-of-court statement offered to prove the truth of what it says is hearsay. There are many exceptions to the hearsay rule, and we'll talk about some of those here in this video seminar, and then you can learn more about that in detail with the tutorial collection. Authentication is simply a question of whether or not a document, usually, has been authenticated, whether it can speak for itself. Certified copies of court orders, for example, are self-authenticating. A certified copy of a death certificate is self-authenticating. Certain things are self-authenticated, and certain things have to be authenticated by the testimony of a live witness, either at trial or a hearing or at a deposition. Presumptions are things that cause the court to make a decision with regard to a certain fact situation. They may shift the burden of proof to the other side, such as if someone dies and they wrote a will just 2 days before they died, and they used the attorney of the person that gets everything. The person that gets everything is a golfing buddy and not a family member, and the golfing buddy is the one that brought the lawyer to the house for the elderly person to sign the will, and the golfing buddy is the one that told the lawyer what to put in the will. Then there's a presumption that the will was obtained by undue influence, and that presumption will hold until it's proved otherwise. Privilege is just what it sounds like, and we talked about that a moment ago, and we'll talk about that in more detail in just a second. Privileges are the attorney-client privilege, the spousal privilege, a priest-penitent privilege. You've got to be very, very careful to understand and properly use the evidence rules, because your whole case depends on being able to make a record not only of the law, but of the facts in a way that constitutes admissible evidence. You can put facts into the record, but if they're not admissible, they get stricken, and the case cannot be determined based on facts that are offered as evidence if they're inadmissible.